Hi, I'm Erin Duques. I'm here to talk to you about revocable living trusts. While trusts can be revocable or irrevocable, today I'm going to focus only on revocable living trusts. So let's begin by understanding what a revocable living trust is. This type of trust is created by a written agreement that you sign during your lifetime. It involves three parties: the grantor or signer, the trustee, and the beneficiaries. When signing a revocable living trust, you are ordinarily all three. All assets titled in this trust are available to you during your lifetime, and all income generated from these accounts is reported on your personal income tax return, so you do not need to file a trust income tax return. However, assets in a revocable living trust are considered available assets for state tax purposes, and they are not shielded from creditors or protected from the cost of long-term care. A revocable living trust has three primary benefits. The first, keeping your affairs private, because unlike a last will and testament, a living trust is not available to the public when you die. The second, incapacity planning, because it's often easier for your successor trustee to manage trust assets rather than relying on a power of attorney. And the third, avoiding probate. When you pass away, the living trust terminates and the assets pass directly to the named beneficiaries. Consequently, assets in a revocable living trust bypass probate because the trust is an entity, not a person. This only works, however, to the extent that you transfer assets to the living trust during your lifetime. Remember, to reap the benefits of a trust, funding it is a must. Typically, assets you transfer to a living trust would include bank accounts, brokerage accounts, real estate, and even personal property. If you transfer real estate to a revocable living trust, nothing changes in terms of your ability to deduct the real property taxes on your income tax return, and you are still entitled to the capital gains tax exclusion if the trust sells your primary residence. Keep in mind that any asset that has a named beneficiary, such as IRAs, 401ks, annuities, and life insurance policies, already avoid probate, so these would not be transferred to a revocable living trust. It's also important to know that any asset that you own jointly with another person would transfer upon death to the surviving joint owner and would avoid probate. A revocable living trust is not necessary for everyone. If you would like help determining whether this type of trust is advisable for you, please reach out to one of our attorneys. We're happy to help you.